Thank you so much for joining us today for our Contract Horror Stories webinar. Again, I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeens Law Firm. And today we have attorney and owner of the Cromeens Law Firm and the Subcontractor Institute and best-selling author, Karalyn Cromeens. The Cromeens Law Firm is a full-service construction law firm. We have offices in Houston, San Antonio, and Austin, and we serve all of Texas. And the Subcontractor Institute is an educational platform with so many free resources for contractors, material suppliers, and now the firm and Subcontractor Institute, we now offer contract reviews and liens and collections nationwide. This has been a really exciting week for us. We had a book launch. It's Karalyn's second book, Quit Getting Stiff, that launched this week. And it actually went bestseller yesterday. So congrats, Karalyn, on that. We also launched our liens and collections initiative in all 50 states. This has the lien breakdown for all 50 states. We break down, we provide this for contractors nationwide, which is step-by-step directions in plain English on how to file your liens and collect the money you're owed. So be sure to check out that. Karalyn has been on a mission from the start to level the playing field and spark change in the construction industry, and has been committed to continue to pave the way for her clients and learning how to protect them on the front end. And also, Karalyn will be speaking at the FCA Leadership Conference in Las Vegas in March, so we hope to see you all there. Today she'll be breaking down everything you need to be aware of in your contracts, because what you sign in a subcontract will be used against you, and signing one bad contract can potentially put you out of business. We'll be going over different clauses, what they look like, how to negotiate those clauses in your contracts, and what you can eliminate from those clauses to protect yourself and your business. And we'll be educating on the dangers of termination for convenience, as well as certain payment terms. And she'll be doing a little storytelling as well on some past horror stories from contractors past. So we really hope you enjoyed this webinar. We're very excited to be with you today. And please follow along with the handout that was emailed out as well. And we'll have that Q&A portion at the end, so you can ask any and all questions you have for Karalyn. All right. And Karalyn, I'm going to let you go ahead and take it away.
Thank you so much, Lee. You make me sound so good. Before I dive into all this very exciting and scary and real risk information, I just want to take a second and share with you my perspective, because I think it matters in the way I view things and how I interpret things. Is that I'm from the Midwest. I grew up in a small town in Illinois, and my dad was a farmer. My mom was a waitress. And I had uncles that were subcontractors, and some of my first jobs were at my uncle's irrigation company, trying to help keep the business running. And so when I look at contracts, and this particular webinar is on contracts that you sign to go to work. So normally a subcontract is what it's about, not one that you drafted or created, but so you're signing somebody else's contract. And I didn't realize then I hadn't been through all this, the dangers that are in some of those contracts, and how harmful they could be to a family small-owned business, especially. And so I come at this from, I have a soft spot for small family-owned businesses that, like what I like to call the get shit done tribe, the people that actually build things and with their hands and get things done. And that group of people, especially to me, deserve to know the risk and to be protected. And so that's what the Subcontractor Institute is all about. There's so many free things there, just educational to help you guys run better businesses. And really, this is the stuff we're going to cover today is going over some of the huge risks that are out there in contracts. So I just wanted to tell you that so you can know where I'm coming from and how I'm viewing things, and that I've been through this. Okay. All right, so the first thing we're going to start with is the difference between bid and scope. And so I want to start here with the bid. What is a bid? A bid is your offer to do work for a certain price, right? And we're going to go over here in a second the different ways that you can do that. But what I wanted to say is that actually I had a story come in on the bid specifically, just here in the last couple of weeks. I had a client call And back in the late 2019, they did a bid for a project. They submitted the bid, they signed the general contractor's paperwork. When the subcontract came around, they're like, hey, no, yeah, we don't want to do this work because so much has changed since then, because it was, the end of 20 by the time the subcontract came around. And they said, no, we're not going to take the job. And so of course, when the job, they hired somebody else, and and they were a glass contractor, and the increase in price from their bid to the contract that they did hire was $150,000. And most of that was because of material and labor costs from, the end of 19 to now. The problem that I see with this, and I'm not quite sure how we're going to get out of it, is that when they submitted their bid, they signed this piece of paper that said, hey, you're submitting this bid, you realize that we're relying on this, and then we can rely on it, and you're legally obligated to do the work for this price. And when they didn't sign the contract and they didn't move forward, they agreed to that. So I'm not quite sure how it's going to play out, but it's not looking that good just by the terms of the document. So we're going to go into what a bid should include. Here is your job details, estimate for the work. There's, two different ways to do a bid, which is just a flat bid, which says, I'm going to do all the plumbing work for $10,000, all the plumbing works that are in the plans and specification for $10,000. Or you can specifically say it's this many feet of, and then specifically put the price there. And in an itemized bid, I always recommend that you do an itemized bid. That way, if the offer is accepted, it's actually what's in that bid that's what accepted, as opposed to if you do a bid that says, I'll do all the plumbing work for a flat price. Now, if you miss something in that bid, you're now on the hook to do all of it for that flat fee price. So make sure we do an itemized bid that says, I'm doing XYZ for the certain dollar amount. And the other thing now, especially when you're doing bids out here, and because of COVID, is that I would put limitations on the bids. Like, this bid is only good for 30 days. And if there's an increase in material over 2 or 3%, I'm entitled to get that increase, because like what happened to my client from earlier is that if you don't do that, you're basically on the hook to do that work for that price, regardless of what the material cost or labor costs are at the time that you sign that estimate. And sometimes, especially if there's been a gap from like 19 and it wasn't signed until the middle of 20, that some of these subcontracts are taking a lot longer. So building that in the bottom of your bid to protect yourself, that if it's outside a certain time frame or if things have changed, you're not locked into that price. Hugely important. And it's hugely important too, although, can you go back one? Just give me 1 second. There you go. Although your bid is an offer and can be accepted, if you sign a subcontract, it does not be, or a different contract, your bid does not become part of that contract. And why does that matter? Because, I can tell you how many times I didn't bid that. When somebody comes to me and say, hey, I didn't agree to do this work. And they don't realize that your bid that you put in that is accepted can't be used to describe the work you're hired to do if you sign a contract with can you go to the next slide now, Lee? With a scope. Okay, so the bid is the process initially. You put your bid out there, it's accepted, you get a contract back. This contract is going to have a scope attached to it, which almost always is 100% not exactly the same as what you bid. So like, you looked at the project schedule, all of that, you looked at the plans, everything, and you made a price. Sometimes the plans have changed. Sometimes there have been RFIs that have been answered that have changed your scope of work. And so by the time you're getting that subcontract, most likely your scope of work has changed. So what I always tell my clients is, like, when you get a subcontract in, the first thing you do is look at that scope as if it were a new project, and see if you come up with the same numbers that you did the last time. Next slide, Lee. Thank you. So your bid was accepted, you get the subcontract. There's, two things. You're going to go through the scope, just like I said. You're also going to go through the contract, right? even if you don't have an attorney to negotiate it, you can hire, like my firm does it for a flat fee. There are other firms out that will interpret it. These contracts are not set up that it's easy for, it's not even easy for me to read. And I've been in legal and in the legal industry for a long time, and it still takes me a long time to read what some of these are saying and understand what they mean. So if having somebody break it down into plain English, this is what you're agreeing to. You know, this is the, you know, you need to have XYZ included with your pay app. You know, you need to make sure, and we're going to go over the pay when paid clauses and what that means and how that works, and know all those risks before you go in. So review the contract and understand it. Here's all the things that are included in the contract. So you get a contract and you think, this is the only thing that I have to follow is this contract. I'm going to sign it. We're good. Okay. All of these other things that are on the screen here are also part of your agreement. So the whole agreement encompasses all of these different documents. And the one there that's bolded, I really want you to pay attention to. In every subcontract I've seen since I've started reviewing them 17 years ago, the subcontract incorporates the terms of the contract between the owner and the general. There's a huge problem with that. You don't get a copy of that contract. So basically they're saying, going in blind, you're just going to agree to this terms of the contract and you have no idea what that is or what it says. And so I have some language for free at Subcontractor Institute that can help you negotiate this term, because basically you want to say, first, I would request to take it out. What it is legally is a catch-all, right? So some attorney is afraid they're going to miss something. So they'll be like, okay, just in case I missed it here, we're going to make you responsible for this whole other contract and you're agreeing to it. So it really shouldn't be in there. You should just be responsible for what's in your contract. But even that, if they won't remove it, that's fine. Then give me a copy of it. It is beyond unreasonable to expect somebody to be held responsible to the terms of a document they have never seen. And so if you explain it like that, be like, would you agree to be bound by some document that I made up and never showed you? So know that going in, like every subcontract I've seen has made you responsible for all of the different terms under the prime, which could be different than the terms of your contract. So have it removed or ask for a copy of it. The other ones you guys know: plan, specifications, schedule, pay applications, all of those exhibits and everything that's referenced in that contract becomes part of the contract. And what does that mean? That becomes part of the terms of the agreement between you. And it's important that we know that all those things work together and you're held responsible for all of those things. Negotiating. Okay. So when I was going back, the difference between bid and scope, don't ever sign a contract that is not correct. So if you get a subcontract or a contract with a scope that is bigger than what you agreed to do in your bid and will cost more money, that contract needs to be redone before you sign it. Okay. Don't ever just say, oh yeah, we'll change that later. We'll get to it later. Just sign that one. No, don't do that, because what you sign is the agreement. And the fact that he or she or somebody may have said that they'll give you one is no evidence and is not legally binding on somebody who says it. And that's the thing about, once you have a contract, that's the agreement, that's what's relied on. Anything outside of that has to be signed, changed in writing and signed by both parties. So the agreement that you sign is what you'll be held responsible to. So, you know, and I think I know I have a letter that you can use for free at the Subcontractor Institute that says, hey, you know, I got this subcontract, the scope on here is different than what the original documents were. There's this XYZ additional work, which is going to cost an additional price of XYZ. Can you please redo the contract and I'll send it back and I'll sign it. And the main thing is with all of this, guys, just from my experience, emails, documentation that these things are going on are hugely important if there's a dispute later on. And then being able to find those things and so that they're well organized will save you time and money. So don't ever sign something that's not correct at the time that you're signing it, or is not what your agreement is supposed to be, especially based on somebody's promise to change it later on. So make sure it's correct. Okay, so there's some other things in here that deal with scope that if you don't deal with on the front end, could end up in expensive litigation, which is not where you want to be. Like I said, knowing what the prime contract is. And here's the other thing you guys got to understand is that first contract that you get in your inbox is the first offer. Contracts are meant to be negotiated. So if you sign that first contract without understanding it or reading the terms or trying to negotiate it, it's like paying sticker price for a car, right? Nobody pays sticker price for a car. It's all in negotiations. It goes back and forth. You don't have to have an attorney do it for you. Subcontractor Institute, I teach, just like this, 20 chapters on all of the dangers in a subcontract and with language in there on how to negotiate. And so if you know what it means and why it's a risk, you can decide whether or not to take that risk or negotiate it. My job as an attorney is to tell you what the risks are, show you what there are, make sure you understand what you're agreeing to. And then you, as a business owner and the one who runs the company and who's making sure people have jobs, have to make the decision of whether you want to just sign it the way it is or negotiate it. And I will tell you that a regular business attorney, if they ever read a subcontract, would never allow their client to sign a subcontract. And that is because subs and people over the year didn't want to rock the boat. They just wanted to get the job. So they just signed it. And a lot of that too is based on the belief that there's some sort of rules that protects people in contracts. And there's some of that on the residential side, but it's more for the homeowner than it is for the builder, but definitely not in commercial. Whatever you sign will be used against you. And so knowing that there's no special set of rules, that you have to stand up and do what's right for your company. And then every time you do that will be easier for the guys that come behind you. And then maybe we can have a turning point on these contracts where they'll be less one-sided. And maybe, my push too is like, let's make them plain English so people can understand what they're signing and they don't have to have lawyers interpret them, because there's no reason to put all this legalese in here. You can do the same thing that you want to do in a contract in plain English, then you don't have to have the legalese. So that's another push of things I'm working on. Let's make things so everybody can understand it. So anyways, bid versus scope, huge issue, and where I see a lot of people make mistakes. So, submit your bid in an itemized form instead of a lump price. Remember that your bid is not become part of the contract and does not describe what you're hired to do. And so the first thing that you do when you get a contract in your inbox, review that scope to make sure it matches the bid. And if it doesn't, make sure it's changed before you sign it. I have several stories on this topic because it happens a lot, especially when, people aren't paying attention, or they work with the same builder for a long time. So they just assumed it's always the same. Super Door subcontractor was a door contractor that did glass doors and other type of doors, was hired to do doors on a community college. Went and installed the doors, was done with the job and wasn't out there for a day or two, and then got a notice letter from the GC. It says, hey, you need to get back out here and finish this job in 48 hours or you'll be terminated. And he's like, what are you talking about? I am finished. And they're like, and I know you have to do the electrical components that make the door work. And he's like, well, I didn't bid that. That doesn't even make any sense. And so he was just going to say, I didn't agree to do that, and was going to walk away. And so he came to see me and I said, well, let's take a second and let's look. I know your bid says something, but what does your scope say? And sure enough, the scope that he agreed to do had all the electrical components. In this case, it wasn't that expensive. I mean, it was a small job anyway, so he lost his ass. But as in the scope of things, it didn't put him out of business. It was painful, but I think it was painful enough that he'll never make that mistake again. And that mistake can happen at a small level or a large level. And if it happens at a big level, it's painful and could really hurt your company. And we'll get into termination and default and why you can't just walk the job if that happens to happen to you, that you won't just get away from it if you do that. Okay, change order. Okay, so like I said before, the contract is the written agreement between you and another party, and that contract is the agreement, and it can only be changed in writing by both parties signing off on it. So that's what we're talking about here. A change order is basically an increase or decrease in the contract price based on either additional work or work being deleted from your scope that changes the contract. And so that's why it has to be in writing and has to be signed by both you and the general contractor. So one of the main provisions that if you get a subcontract, you should read first and be able to understand what's required is the change order provision, because there's no standard set of here's what we're going to do for a change order. Every GC or every person has a different process for getting change orders approved and who can approve change orders and all the different terms. And if you don't do the change order in accordance with the contract that you signed, then you won't be able to get paid for the additional work. So make sure you read before you sign the contract what's required to get a change order signed and see if it's something you can agree to. If the change order provision is like only Jim, who's at the job site for 1 hour on Tuesday mornings at 8 a.m. can sign change orders, you might say, hey, that's probably something I can't agree to because it's just not going to work for me and we need to negotiate this term. So this is another term that you can negotiate. So go in there, read it, find out exactly what's required, so that way you know if you can follow it or not. Another thing that you need to be careful when talking about the change order provision, if the prime contract is incorporated into your contract, you have to follow those change order rules too, if they're different than what's in your contract. And so this is where I see the prime contract used against subcontractors all the time, is because you didn't follow this step for a change order because it was in the prime contract. And then even if you had a signed change order that was in accordance with your contract, you still potentially waive that right because it wasn't in accordance with the prime contract. So just be leery that if you're going to do change orders, that the prime is part of your contract, know what that says too, and make sure it doesn't contradict anything that's in the contract that you're signing. If not, get it changed or try to negotiate before you sign that contract, or know exactly what it says. Okay, so the main thing about change orders, right, is guys, don't do extra work without getting it in writing, signed off on before you do the extra work. It's because the contract says you're not going to be paid for it, and you will end up doing that extra work for it at the end of the day, and would not, extra work and not getting paid. And so this is really something to be careful about. So you have to know, obviously when you're on the job, what your scope is. Your guys have got to know what you're agreeing to do, because if somebody comes and asks them to do something outside that scope and they don't know, and you do it without asking for extra money, then you're not going to get paid for it. I actually had an interesting call on this a couple of days ago, is that I had a sub that did the right thing and finished the job, even though the material costs went up like 50%, and they put in a request for a change order for the increase in material price. Of course, it was never signed off on. And the question was, can I now file a lien for that difference to make sure I get paid that overage? And I think you could legally file a lien, but I don't think it would be enforceable because you agreed in that contract to do that work for that price. So, I don't have a particular slide on this, but before you sign a subcontract, another thing to make sure that is in there that you're going to have to add, because it's not, if you're signing somebody else's contract, it's not going to be in there, is that if material prices increase more than, 2 or 3%, you're allowed to get an, increase in your contract amount for that increase in material or increase in labor. If your contract doesn't have that, you won't get that increased price. And basically you're agreeing to do the job for whatever the material costs are. And so addressing that up front and making sure that it's in there is hugely important. Otherwise, you're not going to be allowed to get that increased price. So some important things about change orders. And like I said, knowing your scope of work is so important. And so you need to know what's included in your scope and what's outside of it. The other thing is that most recently, what I've been seeing in most subcontracts is that even if you disagree on the price, you need to go forward with the work, which is, where's the leverage if they got the work done and you didn't get paid already? So what I like to do, and this is just something that you can think about and something you can negotiate, is that, okay, you're going to ask me to do extra work. If we can agree on a price, great. But if we can't, let's say it's cost plus 15% or cost plus 10%. Let's build in a way out of the change order fight before it happens, right? So if we can't, I give you a price, you know, I, the subcontractor, give you the GC a price for the change order, the extra work that you want me to do, and you, the GC, think it's too high, and be like, okay, well, here's what our agreement says. Our agreement says if we can't agree on it, that it's cost plus 15%. Here's my cost. Let's add 15%, and then it's resolved. If not, you're going to be going and doing this work, and this change order dispute can wait until forever. It's obviously, if you've already done the work, it's not holding up the general contractor at all. So you're just, you know, making continual emails. How are we going to figure this out? Or what am I going to do to get paid? And so if you have it built in, and this is a good idea on any contracts, if you can't agree to the amount of any increased work, it's cost, and you can set the percentage at whatever it is for your company or whatever works for you. It just becomes, especially in these commercial contracts, is that if you have to do it anyways because they asked you to, there's just no leverage left if you don't have a way to resolve it, if you don't agree on the price. So, you know, getting it signed on the front end, having the price set up, having what happens if we can't agree on a price is just makes it so much easier for everybody involved, and make it something that you're going to make money at, right? Like I said, it's all a negotiation. Okay, so most change orders include a clear description of the work, an itemization of what's increased and what's not. The state, you know, regarding the other thing that I see that's missed a lot in change orders is time, right? So at the same time you're doing this change order, this additional work, you have already agreed to finish this project at a certain time on a certain date. And a lot of people just assume, yeah, they know it's going to take me extra time if they give me all this extra work. They might know it, but if you don't get it in writing, at the end of the day, if you finish beyond that completion date that you promised, you could be liable for liquidated damages, which is, you know, $1,000 per day that you don't finish on time. So make sure that we get this assumed, you know, time in the change order, that not only am I going to be paid additional amounts for this work in here, but I get 10 more days because that's how long it's going to take me to do. Because if you don't put it in there, the paperwork tells the story, right? You promised to complete on this day, you didn't. It really doesn't matter why, unless you have something in writing to say, oh, I was actually given 10 extra days because of this extra work. So make sure that makes it into your change order, make sure it's in writing, and make sure it's signed off on by the proper party before you begin the work. The problem is you can't do the extra work and then go back and ask for a change order. I mean, I guess they could give it to you out of the kindness of their heart, which they may or may not do, but you have no legal right to get it if you don't follow the change order process. So just know that up front. Okay, another provision that I've been seeing in subcontracts is that you are required to do your scope of work, everything in the project manual, all of this stuff, and anything else the general contractor can reasonably infer, which is kind of what this slide gets to, is it extra work or not extra work? Well, if somebody can reasonably infer, that gives them unlimited power to say, yeah, you as the mason are doing the bricks, but I didn't put this in your written scope, but I'm inferring that you should have done the loose lentils or the metal portion of that brick too. So you're going to have to do that now because I reasonably inferred. So if you see that language, make sure you take it out. And like I said, know your scope well enough to know what you're being asked is additional work. Hugely important. And another thing, if you're asked to do it verbally and you say, hey, that's a change order, respond with an email. Hey, today I was asked to do this. This is not on my contract. It'll be extra additional work, and here's the price. The big thing is that if there's a disagreement or a potential disagreement, having a written email or a written text you can get away with. Texts are just hard to have as evidence because you have to screenshot it. Right now, it's the only way you can really get text messages into evidence, so it's painful to do. The more emails you can send, the better, but text will work if we have to. But make sure that if there's any contested matters, it's always in writing and well documented. You know, lawyers love paperwork. Well, it's because it's evidence and it's important. So, a horror story. Oh, I have a bad story on this one. I represented a residential home builder, and super nice guy. He went to work for a home builder that actually the owner wrote his own contract, had the contractor sign it, which is kind of odd already, which clearly had in there a written change order provision. But my client's like, okay, well, we're going to work. And all throughout the project, the owner's asking him to do extra things. And he's like, okay, well, he's like, we'll settle up at the end. And so all throughout the project, he's just doing this extra work, and they promise him we'll settle up at the end. And of course, we get to the end of the project. My client has a list of all this extra work that he did, like $125,000, but he doesn't have any written change orders. And so, of course, we send him a letter, we're still unpaid this amount. And we get a letter back that here's the contract that you signed that requires everything in written change orders. So guys, even if they're in, and he was out the money, he didn't get it back. They got a nicer house at his expense. And so here's the thing is, even if they're verbally telling you later on they'll approve it, it doesn't hold up, because it clearly says in your agreement that your agreement cannot be changed unless it's in writing. And adding extra work is a change. And, it really affected my client's business. And they were really limited on the, jobs they can take from there on out, because they didn't have the cash, because all their cash was basically donated to the owner that hired him, that wrote their own contract. And don't get me wrong, it's kind of my client's fault too. They should have read the contract and getting signed change orders. But it just, on that is a huge scale. It kept happening over and over. But here's the thing, it just takes one time, right? Somebody asks you to do something that's outside your scope, and you do it, and you don't get a written change order, and it's not you did it for free. So, and we're in this business to make money. And there's nothing wrong with that. All righty. Payment terms. Okay, this is so important, right? Who doesn't want to get paid for the work that they're doing? Okay, so the first part of payment terms is to read the contract carefully and notice what's required every time you submit a pay app or every time you request payment. Obviously how much work you've done, but lien waivers, insurance things, every contractor or general contractor does it differently. So there's no uniform system of this is what has to be submitted every time. And even people you've worked with for a long time could change this. So once you get that subcontract, dive into and look and see what's required, and make sure you have what they need before it's time to submit the pay app, right? The worst thing is like, pay app's due tomorrow, but I need all this, I need my proof of insurance, I need all this stuff, and trying to get that. And if you miss the timeline, you're going to be, not paid until the next pay app. So make sure you have all the technicals of what needs to be submitted and with your pay app and everything else all nailed down and ready to go way before the first pay app ever has to be submitted. You want to follow their process exactly on the pay app stuff. Okay, so two main contingent payment terms. Legally, they mean two different things. Practically, they're the same thing. But let's just dive into the difference of pay if paid and pay when paid. So the first one is pay if paid. Meaning, okay, so what this says and what this term does is makes payment from the general contractor to the sub contingent upon payment from the owner. Meaning, if the owner doesn't pay the general, you, the sub, does not get paid. And so pay if paid basically means if the owner never pays the GC, then you, the sub, never get paid. In a lot of states, this pay if paid is not enforceable. I know in Texas it's not, and in a lot of other states it's not, because basically it's not a promise at all. It's saying, and so even, at the end of the day, if the GC never gets paid, then there's never an obligation. And so the law has looked at it and said, this is really not a promise. This can't really be a contract. So it's not enforceable. Now, the next one, pay when paid clause, is enforceable in most states. And what it does is the same thing. It just eventually, even if the GC doesn't get paid, they would have to pay you. This is more of a timing thing. If is no promises all. When is like, so the owner pays the GC and then they have 7 days to pay you, right? It's better than a pay if paid, but it's still very one-sided, and it's horrible, if I have to just call it what it is. Because here's the thing, you as a subcontractor could do the greatest job ever. You have painting, you do the best paint job, it looks beautiful. They tell you how great your work is, and like, oh my gosh, I've never seen such great painting. But but then they don't get paid by the owner, and it's 30, 60, 90, 120 days. And you're like, hey, where's my payment? You said I did a great job. Hey, you did do a great job. I just haven't been paid from the owner. And so really that's what a pay when paid clause means. And so I say that to tell you, when you go into these things, negotiate the pay when paid clause. There is some examples of how to do that in your handout. There's also some examples to refer to at Subcontractor Institute. I give 3 different ways to try to negotiate the pay when paid clause. What I do is like, hey, I'm going to submit my pay app. If the GC is not paid by the owner within 30 days and it's not my fault as the sub, it's not my bad work, then GC, you'll pay me my pay app within 45 days. That same situation, owner's not paying the GC, it's not the sub's fault. The GC will pay the sub 50% of that pay app. And the third one is that same situation, GC is not getting paid, but the GC is going to pay the sub to file a lien, whatever that, up to a certain extent. And so and here's the other thing to realize too, is that even if you have a pay when paid clause that you didn't negotiate, one of the most effective ways to get payment if the GC really hasn't been paid is to send a notice of intent to lien. Now, I can tell you from having studied all 50 state lien rights that every state has lien rights. What's required to have a valid lien is the timing of sending notices and filing liens is different across all 50 states, but one thing is the same. You have to send notice before you file a lien, and you have to send, and then you file your lien. And the whole purpose of notice in the lien statute is to give the owner a chance to make sure you, the sub or a material supplier, are paid before they pay the general contractor. And I've seen it happen over and over again. If like you as a subcontractor or your material supplier sends a notice saying, hey, I haven't been paid. If I'm not paid, I'm going to file a lien. If the owner is truly holding on to that payment, most times they can shake it loose, and then the money does come down like it's supposed to. So there are some remedies, even if you didn't negotiate the pay when paid clause, which being a lien notice, and so every state has different timing what's required for a valid lien, but in no state is there penalty for sending it early. And there's no penalty for sending extra notice. So you can send notice early, and you can send it more than what's required by the law. That is the best way to gain leverage without filing a lien, to make sure you get paid and to go around this pay when paid clause. Because what a pay when paid clause does at the end of the day is shift the financing of the project onto the subs and material suppliers, because you guys are the ones that are extending material and paying for labor and then waiting to get paid. So you are extending credit. The owner and the GC are getting the value of that credit and then paying. So although they may have gotten the loan to do the project, you're doing the work and then waiting to get paid. So know that it's in there. Know that it can hurt you if for some reason the owner in general get in a fight that has nothing to do with you, and know your lien rights at the same time. And even if the owner in general get into a fight that has nothing to do with you, if you file a lien or send your lien notice, the owner can pay you directly. So just keep that in mind. Yes, and I have to say too, public projects are some of the worst ones to get paid on. And I know general contractors that do public projects have pay when paid clauses. So if you think about jumping from residential or private commercial to public works, know that the way the government works, either on the state or especially the federal level, is much slower. So the pay is much slower on those types of projects. That's my story that comes with this is a company that I represented that they were working on a college, which was a state college, and they were hired to do 2 parking lots, and that got started, and they dug in, and there was a bunch of issues along the way that had to prove change orders. But the main thing is that my contractor kept submitting its pay applications to the general contractor, but the general contractor kept missing the requirements of what the government entity required to have an approved pay app. And so it was 120 days before he got the first payment. And he's been at work for 120 days. He's had to pay his guys for 120 days. So he's basically maxed out his credit line and is barely getting paid, and then just ran out of money. They couldn't run the project anymore because they didn't have the cash flow and they weren't getting paid enough. And so they had to walk the job. And then when that happened, they got sued, and they got a judgment against them and it put them out of business. So pay when paid clauses can really affect your business. And in the law's eyes, in my client situation, the GC didn't do anything wrong. They were abiding by the terms of their contract that, because our contract didn't say, hey, GC, you have a duty to fill out the pay application to owner correctly. We didn't have any legal standing to challenge that. So just know that those are dangerous things that you'll encounter in every subcontract that's out there to sign, and be wary of it. All right, termination and default. Okay, these words sometimes are used interchangeably, and I wanted you to first take a second and realize they mean two different things. And we're going to dive into what that is and how they work together. So what is a default? A default means you're not doing something you agreed to do in your contract and all the other agreements, which is why it's so important before you sign a contract, you realize what you're agreeing to do. From daily reports to submittals, all of those little things you're required to do. And by not doing them, you're in a default, right? And I know that word sounds, legal and scary, but I mean, it's just basically not doing something you're supposed to do in your contract, not having the insurance required. Most contracts require you to have a safety plan. If you don't have that, technically you're in default under your contract. I mean, they don't really know until they ask you, but those are all things that you need to consider. And here's the other thing, is that a notice of default. What does a notice of default look like? Everybody thinks a notice of default is a letter that comes from a lawyer and is very official looking. It's not. It could be an email. It could be a text that says, hey, you're not doing your job. You're not doing, I didn't get my daily report for the last week. You guys are in default. You're not doing what you're supposed to do. And it doesn't have to say, hey, if you don't fix it, then we're going to terminate you. That's usually what it could end up if they want to. But knowing that an email or a text, something like, is that is a notice of default. And the most important thing you can do is respond in writing immediately or as soon as possible with, yes, I didn't turn in my daily reports, but here they are attached, or I will have them to you tomorrow. Or what if you don't agree what they're saying is a default, like, for example, the electrical components in the door, they're calling you in default, and you actually look at your contract and it's not in there. You say, okay, that's not in my contract. I'm not in default. But whatever it is, respond in writing regardless, that yes, I'm in default and I'm going to fix it, or no, I'm not a default and here's why. That's the most important thing, whatever it is. And then keep records in an organized way so that if a dispute comes up, you'd be like, yes, you sent me that and here's how I responded and we fixed it, or we didn't and here's the reasons why. And here's the bottom line. If you're in default with any of these provisions, technically they don't have to pay you. If you're in default on your side of the contract, they're not obligated to operate under, their side of the contract, which is basically paying you and making sure that you get paid for the work, even if they get paid from the owner. If you're in default, even on the littlest things, they don't have to pay you until you cure that default. So knowing what that is and knowing it, what the default terms in your contract, like every contract will have, here's what makes you in default. We're going to give you, 48-hour notice, and you have to cure that default. And if you don't, they cannot pay you. They can terminate you, which we're going to get into in here in a second too. Okay, so what does it mean if you're terminated? So what normally happens is if you get a notice of default, whether it's via text, official letter, and usually if they're really considering terminating you for cause, they're going to send you a formal written letter, notice of default, that says you have, whatever the contract requires, 48 hours a week to cure this default, because they want it, for their records that they did give you the timely notice that's required by the contract. And then if you don't fix that default, then you can be terminated. So that's how it normally happens. The second type of termination is a termination for convenience clause. And what is that? A termination for convenience clause means you can be terminated for any reason or no reason at all. Here's the big thing about a termination for convenience clause in most subcontracts is that you, the sub, don't have that right. Once you sign the contract, you are on the hook to do that work for that price, and you cannot terminate unless it's for cause, with basically non-payment. You don't have the right to just walk away. The GC, on the other hand, has normally built in a termination for convenience clause, which means they can terminate you whenever they want to. And so you know, in your handout, there's some examples of what these things look like and some ideas on how to negotiate them. Either they're in your handout or at Subcontractor Institute for free. And some negotiation language. What I try to do is have it taken out. If that won't happen, at least try to make it mutual, where you, the sub, can terminate for any reason or no reason at all. It's just such a dangerous provision. And when I normally see the termination for convenience clause used is usually it's right before you're going to start. You get a notice that you've been terminated. And what has happened normally in that situation is that the GC's found somebody else to do your work for cheaper, and they're just going to let you go. The other place where termination for convenience clause is used is if the general contractor didn't follow their own contract and terminated you without giving you the proper notice, meaning they didn't terminate you for cause, and because if they didn't follow their own contract, they'd be in breach of contract and liable to you. So they built in this safety net, which is the termination for convenience clause. Because you'd be like, hey, you didn't terminate me for cause like our contract said. And they're like, no, wait, we have this termination for convenience. So we just fired you for convenience. So basically it's a scapegoat to let the GC out of either finding something cheaper, or if they wrongfully terminated you and didn't use the terms of their own contract to terminate you. Okay, now default termination, and here's another place where I find a big misunderstanding is what happens when you're terminated. A lot of people just think you can walk the job, you're done, there's no liability there. All right, so the first thing that happens if you get terminated or you walk the job, they're going to hold on, the general contractor or owner is going to hold on to any funds that you're currently owed, and they're going to hang on to those. And that GC is going to have to hire somebody to replace you and finish your scope. You go to the next slide. Thank you. And so what does that look like? Especially during the middle of the project, they're not going to be able to find somebody to finish your work for the same price that you would, right? So it's going to end up costing the general contractor more, most likely, to finish your scope of work. And on the top of that, most subcontracts have, if you're terminated and they have to hire somebody to replace you, they can add 15% on that cost to hire somebody to replace you for their administrative fees and having to deal with it. So, you know, whatever it was cost, and, you know, 15% on top of that. And so what happens after that? So whatever the cost is between what you agreed to do the work for and what it cost them to do it, plus that 15%, you're on the hook for, meaning that they can sue you and get a judgment for that amount of money. And so that's why before you walk a job or get terminated, you really need to think about the scope of what could happen. So, you know, because if you're terminated and they find someone cheaper and it actually costs them less, then they owe you money for whatever you would have completed it for. In all of my life, I've never seen that happen, ever. If you get terminated, you're going to be lucky if it's a mutual walkaway and you don't owe them money. So just know that if you're terminated, it's not just losing the money that you're owed. You're potentially on the hook for the difference in the cost of scope, and knowing that on the front end, so you can make an informed decision before you decide to let termination happen or walk the job. The other thing is, if it's a bonded job, like you had to get a bond to the GC, normally it's on Public Works, and you walk the project, or you know, that cost them to, you know, cover your completion is going to be recovered from that bond. And I don't have a section on it here, but there's a really good video on it at Subcontractor Institute, is that if a bond is not insurance. If your bond company has to pay out, they're going to come after you to get that money that they paid out back. They're not in the business of paying claims without getting it back. They're just saying, basically, a bond company saying that you're good for it, meaning that you're good for it, that either the GC will get it from you or they'll get it from you if you default. So know that as well, that if you've terminated on a bonded job, your bond is now up for grabs for the amount that it costs to finish your work. Hugely important. Jesse, the wall covering subcontractor, this is one of the terminations that happened for convenience on the front end. Jesse had bought, you know, the specific wall coverings that this contract required. She had it in stock. She was all ready to go. And then she gets the notice of termination. And that material that she bought that she can't use anywhere else is now hers, because she didn't get the job and it's not on the project, and she didn't have, and when you get terminated for convenience like that, you're not entitled to the profit that you would have made, any expenses you put out in getting the material ready, or any, why can't I think of the word that, you go startup costs, basically. You're not entitled to get any of that back if you're terminated for convenience on the front end. So just know that going in, that's a risk if there's a termination for convenience clause in there. I know this is a lot of stuff and we kind of went over it fast, but it's all so hugely important. And these are just a few of the things. Like we went over these 4 things. There's for free at Subcontractor Institute. There's even more that you should watch out for. These are the main ones that the pay when paid is probably the most harmful. And bid and scope are the 2 big ones that I run into all the time that are really detrimental, especially to small businesses on your business, and, not getting paid. And just the thing is that I find, and everybody thinks that, no, nothing's going to happen. And most of the time you're right. And I hope that it never does, but it just takes one. So, and that's what I'm here to help you to avoid. And I'm here to answer any questions that you have.
Well, very fantastic stuff. Thank you very much, Karalyn. So we're going to go ahead and open it up to the Q&A section now. So if you have a question, you can feel free to raise your hand and we will unmute you and let you ask it. Or if you prefer, you can just post it in the chat and we'll ask it as well. And we actually did have one question come up during your presentation, Karalyn. For change orders, many times it is T&M extra work. Is it at least sufficient to have an email from the PM confirming that they want us to do the work and that is extra?
Yes, it should be enough, unless your contract says that it's not. So, if the contract specifically, and I've seen it before, that a contract specifically says our PM cannot approve change orders by email, then it wouldn't be enough. But normally, yes, it would be. But I would check the terms of your specific contract just to make sure.
Makes sense. Makes sense. The next one, regarding change orders, if we receive an email stating to proceed and that they would issue a change order once it's finalized, is it still acceptable to proceed?
If you have something in writing like that, I would say yes, but still you're going to be fighting about the price. Make sure you save that, but double check with the contract. Because here's the thing that you have to understand is that the guys that are running the job have no idea what the change order term says. And so they either intentionally or not, they might be doing something that they think is okay. But when a bunch of lawyers get involved and they read the technical language of the contract, it won't be. So in writing, normally that, emails back and forth approving, yes, is usually enough. But I would just definitely check the terms of the contract, because that's what's going to be controlling. And sometimes, people have problems with their PMs giving out change orders willy-nilly. And so they limit that in the contract, knowing that, hey, I don't have to manage these guys. You do, because you just agreed that you wouldn't have change orders approved this way. So just look at what the terms say.
Makes sense. Do we have any other questions? Hearing no other questions, Karalyn Lee, thank you very much for joining us today. That was fantastic stuff. And just so everyone, to reiterate for everyone, Karalyn is going to be speaking at our International Leadership Council March 23rd through 26th at the Wynn Hotel in Las Vegas. So hopefully you guys will join us there, because it's going to be I'm sure it'll be another great presentation like this one. And one more question just popped in.
Yes.
Karalyn, do you have your email address?
Yeah, if you want to put it, Lee, if you want to put it in
I'll do it right now.
in the chat. It's my name, which is Karalyn, spelled kind of funny, and then at thecromeenslawfirm.com. So it's super long, but Lee will put it in the chat for you.
I'll put it in for you right now.
Excellent.
There we go. Oops, sorry. Sent that just to Jeremy. There we go. All right.
Okay. Well, fantastic stuff. Thank you again. And I personally look forward to seeing you guys in March at the latest in Las Vegas. And everyone, feel free to send any questions our way or Karalyn's way if you have any additional questions.
Perfect.
Okay.
Thank you
so much. Really
Have a
appreciate
fantastic
it.
day.